Baltimore City Office of Equity and Civil Rights presents Fair Housing for Persons with Disabilities. Topics covered. Today we're going to be reviewing fair housing laws, primarily the Fair Housing Act of 1968 as amended. We'll also be reviewing reasonable accommodations with a real-life scenario and prohibited practices, as well as reasonable modifications, also with a real-life scenario and prohibited practices. We'll be talking about accessible design, fair housing design guidelines, a comparison of the Americans with Disabilities Act and the Fair Housing Act. We'll review additional prohibited practices with a real-life scenario and more prohibited practices. And we'll also go over how to file a complaint and other resources. The Baltimore Office of Equity and Civil Rights. We are a city agency devoted to advancing equity and upholding the federal and local civil rights laws, the local living and prevailing wage laws, and providing oversight of local law enforcement. The mission of the Office of Equity and Civil Rights is to carry out activities to eliminate inequity, inequality, and discrimination. We investigate claims of discrimination and assist people who have been discriminated against by enforcing the laws that protect them. The Baltimore Community Relations Commission combats unlawful discrimination in employment, public accommodation, housing, education, and health and welfare services. Alphabet soup. Here are the definitions to some of the most common acronyms you'll hear used in this presentation. HUD, the U.S. Department of Housing and Urban Development. FHA, the Fair Housing Act as amended. DOJ, the U.S. Department of Justice. ADA, the Americans with Disabilities Act. MCCR, the Maryland Commission on Civil Rights. CRC, the Community Relations Commission. SSI, Supplemental Security Income. SSDI, Social Security Disability Insurance. Let's go over some fair housing laws. First, test your knowledge. Answers to these questions will be provided throughout the presentation. Question 1. What year was the Fair Housing Act amended to include disability as a protected class? The Fair Housing Act of 1968 as amended. It's our federal fair housing law. The Fair Housing Act of 1968 as amended prohibits housing discrimination on the basis of race, color, national origin, religion, sex, disability, and familial status. Here's a short video of the history of the Fair Housing Act.
Few in the nation believed that fair housing would in our time become the unchallenged law of this land. And indeed, this bill has had a long and stormy trip.
Well, I don't know what will happen now. We've got some difficult days ahead. Like anybody, I would like to live a long life. Longevity has its place. But I'm not concerned about that now. And I've looked over and I've seen the promised land. I may not get there with you, but I want you to know tonight that we as a people will get to the promised land. So I'm happy tonight. I'm not worried about anything. I'm not fearing any man.
Ladies and gentlemen, Martin Luther King was shot and was killed tonight in Memphis.
The death of the prophet of nonviolence set off the worst outbreak of arson, looting, and criminal activity in the nation's history. Washington's ghettos burned within a few blocks of the nation's capital.
life of a man who symbolized the freedom and faith of America has been taken. And no words of mine can fill the void of the eloquent voice that has been stilled. But this I do believe deeply. The dream of Dr. Martin Luther King Jr. has not died with him.
President Johnson was willing to speak up and say, we have to pass a fair housing bill.
Hello, Mr. President? Yes, Dick. We're in trouble. We need some help. Yes? I'm afraid of that.
Federal troops, for the first time since the Civil War, took up positions to guard government buildings.
Nothing's probably touchier than your own neighborhood and your own home or your own apartment. The administration, which supported the bill, said this has no chance. The other stuff is okay, but this will kill any politician that touches it.
Well, I just could not live beside them. I don't feel that they should be oppressed. But I moved here because it was a white community.
I have 2 daughters and 2 sons. And if there's too many colored people around here, I definitely will get out.
I think that, well, the property values will immediately go down if they are allowed to move in here in any number.
It seems as though our country is pulling apart into separate societies, where whites have jobs and Negroes have unemployment, where the middle class lives in suburbs and the poor are left in the ghettos, where one group of Americans looks upon another group of Americans with growing mistrust and even dread.
Then the bill went over into the House Rules Committee, and under the chairmanship of the famous Judge Smith, a right-wing segregationist from Virginia, he wouldn't hold hearings on it. He would take the bill home so nobody could act on it, and we were running out of time.
Thousands flowed through the rainy streets of Memphis this day, finishing a march that Dr. King planned to lead in support of striking garbage workers.
How many men must die before we can really have a free and true and peaceful society?
For your presence, Lord. And I know you'll reach out and take mine. You take our hand.
The death of Martin Luther King is a tragic thing, but no legislation should be passed as a memorial to anyone.
In spite of the riots, I am going to support this legislation with all the vigor that I possess.
The laws that we pass up here are for all time. The Martin Luther Kings come and go.
The public reaction to this horror gave the sensible members of the committee a compelling argument that the House Rules Committee had to report that bill out. And I think that's how we got our bill. They just didn't dare bottle it up any longer.
And I have a dream that one day Negroes will be able to buy a house anywhere that their money will carry them.
At long last this afternoon, fair housing for all is now a part of the American way of life. Democracy's work is being done, and the bell of freedom rings out a little louder. We have come some of the way, not near all of it.
fight still goes on because we unfortunately have the laws, but we don't have the enforcement. That we have changed, but we still have the same kinds of discrimination.
The U.S. Commission on Civil Rights said today that efforts by federal agencies to end housing discrimination have been generally superficial or incomplete.
President Carter has ordered federal agencies to use all means possible to strengthen fair housing programs.
For the first time, people with disabilities and families with children will be protected from housing discrimination.
President Reagan signed legislation today designed to toughen up the nation's fair housing laws.
Why did you take part in this demonstration today? Just because there was a huge crowd, or did you have any personal reason?
Well, I took part in this march today because of Martin Luther King and what he stood for, because this march is what he died for.
You know what he stood for?
Yes. He stood for nonviolence and peace for all men of all kinds. And I think if he died for it, I could carry out what he started.
Disability defined. The Fair Housing Act defines persons with a disability to mean those individuals with mental or physical impairments that substantially limit one or major life activities. The term major life activity may include seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking, or working. The Fair Housing Act also protects persons who have a record of such an impairment or are regarded as having such an impairment. Here are some examples of disabilities: hearing impairments, mobility impairments, HIV infection, alcoholism, prior drug addiction, chronic fatigue, learning disabilities, head injuries, mental illness, and vision impairments. Section 504 of the 1973 Rehabilitation Act prohibits discrimination against people with disabilities in programs that receive federal financial assistance. Title 20 of the Annotated Code of Maryland. It's our state fair housing law. State Government Article 20-702, Annotated Code of Maryland, prohibits housing discrimination on all federally protected bases, in addition to marital status, sexual orientation, and gender identity and expression. Article 4 of the Baltimore City Code is our local fair housing law. Article 4 prohibits housing discrimination on all federal and state protected bases, in addition to age, ancestry, and source of income. Remember, all housing transactions are covered under fair housing laws: rentals, sales, insurance, and planning and zoning. Planning and zoning. The Fair Housing Act prohibits municipalities and other local government entities from making zoning or land use decisions or implementing land use policies that exclude or otherwise discriminate against individuals with disabilities. Here's a short video on the history of discriminatory housing practices.
Hello. My name is Alexander Lawstein. I'm the Museum Learning Manager here at the Maryland Historical Society. We are in the H. Furlong Baldwin Library, where he has around 7 million documents, some of which will be highlighted in this video. This video will explore the history of housing discrimination in Baltimore City, particularly towards Black Baltimoreans. In 1937, the Federal Homeowners Loan Corporation published its residential security map of Baltimore. This map, geared towards mortgage lenders, graded the potential lending risk factors and desirability of neighborhoods in Baltimore and many other cities throughout the United States. While initially part of the New Deal's National Housing Act of 1934, intended to help prevent foreclosures, these maps soon became a symbol of race-based housing discrimination. Areas in green or Grade A areas were the most desirable, blue or Grade B were next, then yellow or Grade C, and finally, the least desirable, most risky areas were the red or Grade D neighborhoods. White neighborhoods tended to fall within green and blue grades, immigrant neighborhoods were blue and yellow, while black neighborhoods tended to be redlined. This redlining in 1937 was not new to Baltimoreans, as it was the result of decades of housing discrimination. Following the Civil War and through the early 1900s, white Baltimoreans used housing ordinances, homeowners associations, and block busing to segregate and discriminate against black Baltimoreans. Before the Civil War, Baltimore was fairly mixed with white and black residents living amongst each other, although white residents tended to live on main streets and black residents tended to live in the alleyways. Following the Civil War, an increase in black and European immigration to Baltimore, coupled with new public transportation options and the Great Baltimore Fire of 1904, began to lead to white middle-class flight. As white Baltimoreans began to leave the inner city, followed by ethnic groups such as Jewish immigrants, there was no official housing segregation policy stopping upper and middle-class black families from following the same trajectory. Nevertheless, most realtors would not sell to black families. If a house was going to be sold to a black family, it would have to be done by the owner themselves. This is what happened in 1910 with the purchase of 1834 McCullough Street by W. Ashby Hawkins, a prominent black attorney. This sale and subsequent rental to his law partner, George McMecken, began a series of official and unofficial housing segregation policies in Baltimore City. Unofficially, this sale began a pattern of selling in which white Baltimoreans would sell to Jewish homebuyers who would then, and only if their neighborhood or block's market was in a slump, would sell to black families. This pattern of secession primarily took place in the Old West Baltimore neighborhoods of Upton and Druid Heights. This block breaking, or busting as it was sometimes called, scared many white homeowners and city government officials. One of the first official policies was Baltimore City Ordinance 610, also called the West Plan, named after Councilman Samuel West. This ordinance stated that no black resident could move into a block in which more than half of the residents were white and vice versa. It also stated that existing conditions would not be disturbed and no one would be forced to move out of their neighborhood. This ordinance was the first of three, but had the largest impact as many southern cities began to replicate the Baltimore idea. The Baltimore idea led to crowded black neighborhoods in Baltimore City. It wasn't just housing ordinances that stopped black Baltimoreans from leaving the city, but also homeowners associations. As upper and middle class white families began to leave the city, the Roland Park Company developed neighborhoods for these families. Before buying a home, a family had to agree to a set of rules, also called a neighborhood covenant. One of these rules, in a 1913 agreement for the Guilford neighborhood, under the nuisance section, stated that at no time shall the land included in said tract, or any part thereof, or any building erected thereon, be occupied by any Negro or person of Negro extraction. This segregation from private neighborhoods began even before the West Plan was implemented, and in response to the creation and segregation of these private neighborhoods, specifically the Roland Park neighborhood, construction and realty companies began developing neighborhoods for middle-class black Baltimoreans. One specific neighborhood was Cherry Heights neighborhood, represented legally by Hawkins and McMecken, which was touted as having lots as beautiful as Roland Park. Although the Baltimore idea was found unconstitutional by the Supreme Court in 1917 in Buchanan v. Worley, in which they argued that civil government racial segregation in housing violated the 14th Amendment, the damage caused by Ordinance 610 and the private HOAs was seen in the 1937 residential security map. Black neighborhoods in Baltimore suffered from high rents and poor quality housing due to blockbusting and deceptive practices that came with the industry and limited social and city services, which led to Grade D or red markings. The effects of housing discrimination in Baltimore in the 1910s to 1930s can still be seen in residential maps of Baltimore today. Many of the neighborhoods where people of color live in Baltimore today are the same neighborhoods that they were forced to live in due to housing discrimination ordinances and redlining in the 1910s to the 30s. Over these 30 years, the consistent housing discrimination and unethical practices by renters limited the ability of many in the black community to accumulate wealth, while at the same time stigmatizing neighborhoods, decreasing the number of social programs, limiting access to public works, and heightening the police presence in neighborhoods deemed undesirable. Although the 1968 Fair Housing Act outlawed discrimination of this type, the legacy and continued unequal treatment still affects Black communities today.
Remember, all individuals involved in housing must comply with fair housing law. Maintenance and contractors, safety personnel, marketing and administrative staff, and more. There are some exemptions from the Fair Housing Act. Owner-occupied buildings with no more than 4 rental units, the Mrs. Murphy exemption, the owner must reside in one of the units. Single-family housing sold or rented without the use of a broker if the private individual owner owns no more than 3 such single-family homes at one time. Housing operated by religious organizations and private clubs that limit occupancy to their own members. Housing exclusively reserved for senior citizens. All the residents are age 62 or older, or at least 80% of the occupied units include one resident 55 or older, and the community shows an intent to provide housing for those 55 and up. Exemptions from Article 4 of the Baltimore City Code. Single-sex housing, where the physical limitations or configuration of the housing facility or considerations of personal privacy or personal safety make it inappropriate for the facility to be occupied by persons of both sexes. The rental of not more than 2 rooming units in the dwelling unit by any person if the person resides in the dwelling unit. 17,575, the number of complaints of housing discrimination based on disability in 2018 nationally. Reasonable accommodations. Test your knowledge. Question number 2. Who is responsible for the costs of reasonable accommodations? Reasonable accommodations. A reasonable accommodation is a reasonable change in rules, policies, practices, and services which may be necessary to afford a person with a disability an equal opportunity to enjoy and use a dwelling. Management is responsible for the costs associated with a reasonable accommodation. Housing providers may not require persons with disabilities to pay extra fees or deposits or place any other special conditions or requirements as a condition of receiving a reasonable accommodation. Here's a video on an example of reasonable accommodation.
Come on, girl. Come on. Hi, how are you doing today? I'm good. Come on, girl. Hi. So I just recently got a support animal. Her name is Luna. Okay. I live in Unit 301, so I'm just notifying you of the change.
Oh, well, our policy specifically states no pets, and you knew this when you moved in, and I'm sorry. The only thing that I can advise you on, as well as the agency, is that you could probably get rid of her, or you should get rid of her, and because we can't have her messing up the carpet.
I can't just get rid of her. She's my emotional support animal.
Well, like I explained before, there's a policy in place, and there are no exceptions, and we can't help you.
No exceptions? Can they do that?
Looks like we came in at just the right time. Hi there. We're the Baltimore City Community Relations Commission of the Office of Equity and Civil Rights. We get calls all the time from people wanting to know their housing rights. Let's talk a little bit about what housing rights are and take another look at that scenario. Under the Fair Housing Act of 1968 as amended and Article 4 of the Baltimore City Code, it is illegal to refuse to provide a reasonable accommodation to a person with a disability. Refusing to make an exception to a no pet policy for an assistance animal is housing discrimination. Let's return to our scenario from before and see if things can turn out differently.
Come on, girl. Hi, come on. Hi, how are you today?
Good, how are you?
Good. I just recently got an emotional support animal, so I'm just notifying you of the change.
Oh,
I live
great.
in Unit 301.
Okay. Well, you know, we have a no pet policy, but you would have to pay a special deposit of $500. And what exactly is your disability?
$500? What is my disability? This feels wrong too. Can they do this?
Providing a reasonable accommodation would also include an exception for any pet deposits. A housing provider can ask for supporting information to show that the person seeking the accommodation has a disability. They can also ask for information that reasonably supports that the animal does work, performs tasks, provides assistance, and/or provides therapeutic emotional support with respect to the person's disability. However, they should only collect the information they need. Let's revisit our scenario one last time to see if the situation changed for our resident.
Come on, girl. Come on. Hi, how are you today?
I'm great. How are you? Have a seat.
Hi. So, I live in Unit 301.
Okay.
I just got an emotional support animal, so I just wanted to notify you of the change.
Okay, well, thank you for notifying us. What we'll have to do is we'll have to have you fill out the necessary documents. It's going to include your name, the type of animal, also a letter from your healthcare provider, just so we'll know.
Okay. That works for me. That works for you. That works for me.
That scenario shows that discrimination can be both overt and subtle. It also demonstrates how housing providers should handle reasonable accommodation requests. Now that you have seen an example involving an assistance animal, let's discuss assistance animals in more detail. HUD 2020 Assistance Animal Notice. This guidance explains certain obligations of housing providers under the Fair Housing Act, or FHA, with respect to animals that individuals with disabilities may request as reasonable accommodations, and the documents providers may require. Types of assistance animals. There are two types of assistance animals. 1, service animals, and 2, other trained or untrained animals that do work, perform tasks, provide assistance, and/or provide therapeutic emotional support for individuals with disabilities. What housing providers may ask. For non-observable disabilities, a housing provider may request information regarding both the disability and the disability-related need for the animal. Housing providers are not entitled to know an individual's diagnosis. Reasonable accommodations can be adjusting a rent payment schedule to accommodate when an individual receives income assistance, permitting a tenant to transfer to a ground floor unit, permitting an applicant to submit a housing application via a different means. Reasonable modifications. Test your knowledge. Question 3. Who is responsible for the cost of reasonable modifications? Reasonable modifications. Under the Fair Housing Act, a reasonable modification is a structural change made to existing premises, occupied or to be occupied by a person with a disability, in order to afford such person full enjoyment of the premises. The tenant is typically responsible for the costs associated with a reasonable modification to their dwelling. Reasonable modifications. Under Section 504, reasonable accommodations and modifications must be provided and paid for by the housing provider, unless providing them would be an undue financial and administrative burden or a fundamental alteration of the program. Here's an example of reasonable modification.
Good morning.
Good morning. How you doing?
All right, I just moved into apartment 202, and I'm thinking I may need some modifications done to my place.
Modifications? Look, I don't even let the other tenants paint the apartments. I don't think I can let you make any changes. You knew you were going to need that when you signed your lease.
Because I'm potentially looking at putting some grab bars in the bathroom.
No, we're not going to be able to do that for you.
Oh, really?
I'm sorry.
That sounds like discrimination.
It is. Under the Fair Housing Act, a housing provider is required to allow a reasonable modification needed by a tenant with a disability. Common examples of modifications include ramps for wheelchairs, grab bars in bathrooms, and removal of thresholds from doorways. A housing provider can only deny a request if it will not be completed in a workmanlike fashion or if the resident does not have an appropriate permit in place. Let's visit our landlord and resident again and see what's changed.
Good morning.
Good morning. How you doing today?
All right, I just moved into apartment 202, and I'm thinking I may have to do some modifications to the apartment, like grab bars in the bathroom and maybe widening the bathroom door. I'm looking at hiring my own contractor and paying for it myself.
Okay, well, I'm glad to hear you'll be paying for it, but I don't know about you hiring your own contractors. I've got my guys that I like to work with, and I think you're going to have to use them.
Actually, I think that would make it harder than it actually has to be.
A housing provider cannot condition an approval for a reasonable modification for any reason. A housing provider can only deny a request if it will not be completed in a workmanlike fashion or if the resident does not have appropriate permits in place. A housing provider cannot request that all modifications be returned to the same condition if they will not affect the living conditions of the next tenant. Things like widening doorways will not affect another tenant's ability to use and enjoy the dwelling. Other modifications, like lowering countertops, may be required to be returned back to the initial condition. Let's visit our resident and landlord one last time.
Good morning.
Good morning. How are you doing today?
Oh, fine. I just moved into apartment 202, and I was thinking that I could looking at the possibility of doing modifications.
Okay, what kind of modifications?
Widening the bathroom door and putting grab bars in the bathroom. And I'm looking at the possibility of paying for it myself with my own contractor.
Okay, that works for us. If you're paying for it and you're hiring a contractor, just make sure he does it in a workmanlike fashion and that you have all the right permits.
Yes, ma'am. Yes, ma'am.
That scenario shows that discrimination can be both overt and subtle. It also demonstrates how housing providers should handle reasonable modification requests. Now that you have seen an example of a request for a reasonable modification, let's discuss a few more examples. Reasonable modifications: installing grab bars to facilitate use of bathroom facilities, widening of a doorway to accommodate a wheelchair, lowering of countertops, installing an accessible shower, changing out carpet for hardwood flooring. Maintenance of modifications: the tenant is responsible for upkeep and maintenance of a modification that is used exclusively by her. If a modification is made to a common area that is normally maintained by the housing provider, then the housing provider is responsible for the upkeep and maintenance of the modification. But what if the housing provider wants a more costly design for the requested modification? If the housing provider wishes a modification to be made with more costly materials in order to satisfy the landlord's aesthetic standards, the tenant must agree only if the housing provider pays those additional costs. What types of documents and assurances may a housing provider require regarding the modification before granting the reasonable modification? A description of the proposed modification, both before changes are made to the dwelling and before granting the modification. A description of the modification to be made may be provided to the housing provider, either orally or in writing, depending on the extent and nature of the proposed modification. Any building permits needed to make the modifications, and that the work be performed in a workmanlike manner. If a person with a disability has made reasonable modifications to the interior of the dwelling, must she restore all of them when she moves out? The tenant is obligated to restore those portions of the interior of the dwelling to their previous conditions only where it is reasonable to do so and where the housing provider has requested the restoration. The tenant is not responsible for expenses associated with reasonable wear and tear. Test your knowledge. Question 4. When can a tenant request a reasonable accommodation or modification? Reasonable accommodations and modifications can be requested at any time, not only when a tenant first moves into a dwelling. What can a housing professional ask about a disability if a tenant requests an accommodation or modification? Observable disabilities would not require the housing professional to inquire any additional information. Observable impairments include blindness or low vision, deafness or being hard of hearing, mobility limitations, and other types of impairments with observable symptoms or effects. If a disability is not observable, what information can a housing professional request? Information confirming a person has a disability. This does not require specific diagnosis information. Information confirming an individual has a disability could include such things as a determination of disability from a federal, state, or local government agency, receipt of disability benefits or services, eligibility for housing assistance or a housing voucher received because of a disability, information confirming disability from a healthcare professional, accessible design. Test your knowledge. Question 5. How many basic accessible designs are required by the Fair Housing Act? Fair Housing Accessibility Guidelines. Multifamily housing constructed for the first occupancy after March 13, 1991, i.e., buildings consisting of 4 or more units, must be fully accessible to persons with disabilities. If a building has an elevator, all units must be accessible. If there is no elevator, only ground floor units must be accessible. The Fair Housing Act requires 7 basic accessible designs. Number 1, an accessible building entrance on an accessible route. All covered multifamily dwellings must have at least one accessible building entrance on an accessible route unless it is impractical to do so because of the terrain or unusual characteristics of the site. Number 2, accessible public and common use areas. Covered housing must have accessible and usable public and common use areas. Public and common use areas cover all parts of housing outside an individual unit. They include, for example, building-wide fire alarms, parking lots, storage areas, indoor and outdoor recreational areas, lobbies, mailrooms and mailboxes, and laundry areas. Number 3, usable doors. Usable by a person in a wheelchair. All doors that allow passage into and within all premises must be wide enough to allow passage by persons using wheelchairs. Number 4, accessible route into and through the dwelling unit. Number 5, light switches, electrical outlets, thermostats, and other environmental controls in accessible locations. Number 6, reinforced walls in bathrooms for later installation of grab bars. Reinforcements in bathroom walls must be installed so that grab bars can be added when needed. The law does not require installation of grab bars in bathrooms. Number 7, usable kitchens and bathrooms. Kitchens and bathrooms must be usable. That is, designed and constructed so that an individual in a wheelchair can maneuver in the space provided. ADA versus FHA. The Americans with Disabilities Act, or ADA, is a civil rights law put into place to protect people with disabilities in all areas of public and private life. These include employment, education, transportation, and all places that are open to the general public. The purpose of the ADA is to ensure those individuals with disabilities are treated fairly and the same as those who do not have a physical or mental disability. Both the ADA and the Fair Housing Act, or FHA, are civil rights laws. However, the FHA governs private communities. ADA only applies to places of public accommodation. ADA only prohibits discrimination based on disability. Accessibility guidelines. Certain public use and common areas of dwellings may also be covered by the ADA, as well as the Architectural Barriers Act and Section 504. This would include locations like rental and sales offices. However, strictly residential facilities are not considered places of public accommodation and would not be subject to the ADA, only the FHA. Service animals versus assistance animals. The ADA defines a service animal as any dog that is individually trained to work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. Emotional support and assistance animals that do not qualify as service animals under the ADA may nevertheless qualify as reasonable accommodations under the FHA. Additional prohibited practices. Prohibited practices: discrimination based on association. The Fair Housing Act protection against disability discrimination covers not only home seekers with disabilities, but also buyers and renters without disabilities who live or are associated with individuals with disabilities. Here's an example of discrimination based on association.
EJ, we're gonna go in here. You okay? Come on. Hi.
Good afternoon. How are you?
I'm pretty good. We came in here to look at some units.
Okay.
Okay.
Good afternoon. How are you? Will he be going on the tour?
Yes, he's my son.
Okay. What's wrong with him?
Nothing's wrong with him. He has autism.
Okay. Well, I think it might be better for him or you to look somewhere else. It may make some of the residents here in the building feel uncomfortable. So it might be better that you look somewhere else.
Did he just say that to me?
This is definitely housing discrimination. Under the Fair Housing Act, it is illegal to discriminate against a person because of the disability of a person with whom they are associated. Prohibited activities also include asking about a person's disability. Let's revisit our resident and landlord to see if anything changed.
You okay? Yes. All right, come on, we're gonna go in here. Hi, how are you?
Good afternoon. How are you?
I'm pretty good.
How are you, sir? Good afternoon.
Hi, well, we're coming here because we were trying to check out some units you have.
Okay, of course. I've got 4 to show today, so let's go take a look.
Wow, that is much better.
That scenario shows both an example of discrimination based on association and how interactions like that should be handled by housing professionals. Now that you've seen one example of discrimination based on disability, let's discuss a few more. Prohibited practices include refusal to rent or sell to a person with disabilities, refusal to accept SSI or SSDI or other sources of income, making housing unavailable, offering different facilities to persons with disabilities, segregation, harassment. Harassment based on all protected classes is prohibited under the Fair Housing Act. This would include sexual harassment. Harassment falls into 2 main categories: quid pro quo harassment and hostile environment harassment. Quid pro quo harassment refers to unwelcome requests or demand to engage in conduct where submission to the request or demand, either explicitly or implicitly, is made a condition related to the sale, rental, or availability of a dwelling. An unwelcome request or demand may constitute quid pro quo harassment even if a person acquiesces in the unwelcomed request or demand. Hostile environment harassment refers to unwelcome conduct that is sufficiently severe or pervasive as to interfere with the availability, sale, rental, or use or enjoyment of a dwelling. Hostile environment harassment does not require a change in the economic benefits, terms, or conditions of the dwelling or housing-related services or facilities, or of the residential real estate transaction. Prohibited practices retaliation. It is unlawful to retaliate against any person because that person has made a complaint, testified, assisted, or participated in any manner in a proceeding under the Fair Housing Act, as well as the state and local laws. An example of retaliation is if management does not renew a lease or orders to evict a tenant who previously filed a complaint against the landlord. How to file a complaint and other relevant resources. Test your knowledge. Question 6. With what entities can you file complaints of housing discrimination? How to file a complaint with the Baltimore City Community Relations Commission. To file with the CRC, the alleged discrimination must have taken place in Baltimore City within the last 180 days. File a complaint online at civilrights.baltimorecity.gov/communityrelationscommission/file or call 410-396-3143. Jurisdictional requirements for filing a fair housing complaint. To file with the CRC, the alleged discrimination must have taken place in the past 180 days. To file with HUD or the Maryland Commission on Civil Rights, the alleged discrimination must have taken place in the past year. To file a private lawsuit, the alleged discrimination must have taken place in the past 2 years. Cases of sexual harassment in housing and pattern and practice cases may be initiated at a later time. What happens when a fair housing complaint is filed with the Baltimore City Community Relations Commission? Let's review a timeline. First, an individual files a complaint. The individual will sit down with our intake officer, who will help draft their complaint, will approve and sign the complaint. The housing provider receives notice. Within 10 days, CRC will inform the housing provider that a complaint has been filed against them. Mediation is offered. Parties can choose to mediate a complaint through a third party at no charge. Both parties must agree to mediation. If not, the investigation begins. Investigation. The assigned investigator will request relevant documents, interview witnesses and others involved, as well as request any other necessary information. Finding. The CRC will make a finding of no probable cause or probable cause. If probable cause is found, conciliation will begin. How to file a complaint with HUD or MCCR. Complaints based on federally protected classes can also be filed with the U.S. Department of Housing and Urban Development, HUD, within 1 year. File online by going to www.hud.gov or call 1-800-669-9777. Complaints based on federal and state protected classes can be filed with the Maryland Commission on Civil Rights within 1 year. Visit mccr.maryland.gov or call 410-767-8600. Here's a video on resources from Disability Rights Maryland.
My name is David Prater. I am a managing attorney at Disability Rights Maryland. Disability Rights Maryland is the protection advocacy agency for the state of Maryland. We are mandated by the United States to advance the civil and human rights of people with disabilities.
And what kind of services do you all provide at Disability Rights Maryland?
So we provide free legal services to people with disabilities. We have a fair housing practice that focuses really on expanding opportunities for safe, decent, affordable, and accessible housing for people with disabilities in the community. Our office really got its start as investigating the conditions in institutional settings like state hospitals, like facilities for people with developmental disabilities. That's really what the protection advocacy agency's initial roles were. But as we as a society have moved away from that model, So really have the protection advocacy agencies' roles grown? And we have found in our practice that the number one barrier to people to moving from institutional settings to community settings is safe, decent, affordable, and accessible housing.
Can you talk a little bit more about the history of institutionalization, specifically in Baltimore, if you're able to?
Sure, I can talk a little bit about it. So really the history of institutionalization is almost a parallel history of segregation of people with disabilities. The idea of disability was at one point considered solely a medical issue, that people with disabilities needed to be shuttered away, kept away in facilities or other institutional settings to be treated or cured of their disabilities. And in fact, at the turn of the century, there were things called ugly laws that prohibited people who were deformed or had other physical disabilities from being in public. And even at the Supreme Court, the case of Buck v. Bell authorized the sterilization of people with disabilities. So there's a long history in our country of discriminating through public and private action against people with disabilities. And what that led to was really turning people with disabilities away into those institutional settings. And even there, those institutional settings were segregated by race. And so as we kind of grew away and grew up and our values changed as a country, we thought maybe just shuttering people away isn't the right way to go, isn't the right way to treat people. And so the Protection Advocacy Agency really grew up around that idea, but it was certainly led by people with disabilities themselves who really demanded their full civil and human rights. And we work closely in partnership with the disability community to hear what those rights are and what those needs are, and where the public and private discrimination continues, how do we root that out to ensure full community integration for people with disabilities?
So you said that today one of the issues facing folks, entering community living is accessibility. Can you talk a bit about accessibility and the work Disability Rights Maryland does around that?
Yes, absolutely. So I think particularly looking at the housing stock in Maryland or the housing stock in Baltimore, there is a significant challenge around accessibility. So what the law requires, really two significant laws. One is the Rehabilitation Act of 1974. Under 504 of that act, recipients of federal financial assistance are required to have accessibility in their programs, and that includes their facilities. And so there's some baseline requirements for accessible units that need to be created if you're a recipient of federal financial assistance. The other significant law is the Fair Housing Act and its amendments of 1988, which requires all covered multifamily dwelling units to have a minimum level of accessibility. So this is good. However, where these statutes may not reach to is into single-family dwellings or townhomes or other kinds of housing. And so there's limitations on those laws. And so one of the challenges, again, for Baltimore, particularly where there's an older housing stock or maybe there's not the same level of multifamily construction, accessibility does pose a real problem. Now, some things that those laws also provide for include a requirement that landlords provide reasonable modifications to people with disabilities. And what that means is that a tenant can request modifications to a unit that will help them have access and use of that unit. And the landlord cannot deny a tenant the right to make those modifications. The landlord may not necessarily have to pay for those modifications, but he certainly cannot deny a tenant the right to make those modifications. But for a lot of people with disabilities, affordability is also a significant barrier.
Can you talk a little bit about why affordability is an issue for folks with disabilities?
Sure. So, and maybe, again, some historical context might be helpful. So, people with disabilities have historically not participated in the workforce at the same level as their non-disabled peers. I think most recent statistics show it's something like like 66% almost. And even for those folks who do participate in the workforce, their pay is not on parity with their non-disabled peers. So there is a challenge there with respect to poverty. So people with disabilities experience poverty disproportionately. So there's a huge affordability gap there. And Title I of the ADA, Americans with Disabilities Act, held the promise of more employment opportunities for people with disabilities. And I would hazard that agencies like yours and the state enforcement agency and the EEOC experience a lot of employment discrimination complaints. And probably similar to housing, the vast majority of those complaints are from people with disabilities in the employment context. So that's one of the reasons why affordability is such a significant barrier for people with disabilities, is that, again, that historical lack of access to employment opportunities. Again, I love history, so I'm going to talk about history. So the history is deinstitutionalization. We've moved away from that model of keeping people with disabilities housed in institutional settings. What was supposed to go along with deinstitutionalization was the buildup of community-based services. So we got about half of the equation right, and we missed out on maybe the most important part of it. So the result has been people with disabilities experiencing homelessness, in part because of the lack of affordable housing, in part because of the lack of access to jobs. And so people who are experiencing homelessness have these routine encounters with police and frequently end up engaged in the criminal justice system. And the criminal justice system is so inappropriately equipped to handle these situations. And so more frequently or not, where people end up when they have contact with the police is jails or hospitals, and in some of the most tragic cases with serious injuries and even in death. So we really can't separate the criminalization of disabilities from the lack of housing for people with disabilities. And that housing may be permanent supportive housing with appropriate services that are selected by the person with those disabilities. It may be other forms of housing that would be necessary for that person to live in a community setting. But those are the challenges I think that my office is really looking at currently. Because if we look at some of the statistics about who populates our jails, who populates our state hospitals, who populates the emergency departments, it's overwhelmingly persons with disabilities and persons with mental illness and intellectual and developmental disabilities. So having those community resources there, housing and services, is just really, really important to continue the work of deinstitutionalization. So we represent people with disabilities, and we do that free of charge. We provide legal representation for people with disabilities who are seeking to enforce their fair housing rights, who are defending their right to access housing in eviction proceedings. And we also do impact cases. So these are the kinds of cases where we're looking at barriers in policies or in institutions that are not really addressing their commitments that are required under the federal civil rights laws for people with disabilities. So I think one of the most significant things that local advocates should be aware of is the criminalization of people with disabilities. Because there is such a dearth of housing and safe, decent, and accessible housing for people with disabilities, we see a lot of folks homeless, involved in the criminal justice system. And what that inevitably means is that our jails are becoming overwhelmingly the place where we now warehouse people with disabilities. So I think what local advocates need to be thinking of when they think about housing for people with disabilities is it's not only about enforcing your rights in housing, but it's also about creating those opportunities in the community to avoid institutionalization and avoid incarceration. So it really is a way to prevent the segregation of people with disabilities.
Now that you have learned about fair housing laws in Baltimore City, let's finish up today by reviewing the Test Your Knowledge questions. Question 1. When was disability added as a protected class to the Fair Housing Act? Answer: 1988. Question 2. Who is responsible for the cost of reasonable accommodations? Answer: the housing provider. Question 3. Who is responsible for the cost of reasonable modifications? Answer: the tenant, except in the case of units that fall under Section 504 of the Rehabilitation Act. Question 4. When can a tenant request a reasonable accommodation or modification? Answer: at any time, including before or during their tenancy. Question 5. How many basic accessible designs are required by the Fair Housing Act? Answer: 7. Question 6. With what entities can you file complaints of housing discrimination? Answer: Baltimore City Community Relations Commission, the U.S. Department of Housing and Urban Development, and the Maryland Commission on Civil Rights. For questions or to request further training, please call the Baltimore City Community Relations Commission at 410-396-3143.